Welcome, everybody, to our webinar today. We are going to try to stay out of legal trouble, and we're going to talk about the essential hiring do's and don'ts for a small business. So if you're a small business owner and you're looking for figuring out what are those things I should be doing or what are those things I should not be doing when I'm hiring, you're in the right place. My name is Chris Igou. I'm the vice president at CareerPlug, and 3 companies have come together today to help provide this great information to you. CareerPlug, Jackson Lewis, and GoSmallBiz. So I'm going to run through the agenda and a couple of housekeepers, and then I'm going to turn it over to our expert here today. So if I can hit the agenda here, what we're going to go through are some introductions. We're then going to go through what a business needs as far as workers. We're going to talk about contractors versus employees. We're going to talk about do's and don'ts in interviewing, post-offer and pre-hire considerations that you should be aware of. We're also going to talk about onboarding and leave you some information about how can you connect to get more information. Team, we only have a short period of time today, and we won't be able to cover everything. So we're going to give you some information at the end on how can you get more information from one of us as well. Couple housekeepers before I kick this over to the rest of the team. We are going to keep everybody muted on this webinar. However, we do ask for you to put your questions in the chat. We're going to answer some along the way, but we're also going to tee some up at the end. With that, Anna, I would love to introduce you. And can you please just give a little bit of background on who GoSmallBiz is and why are we supporting this webinar today?
Absolutely. Thank you so much, Chris, for the introduction, and thank you so much for having us here. So GoSmallBiz has actually been leading the charge for small business SaaS solutions since 1996. Our main goal is to help you protect and grow your business. Our founding motto is the mission of business is to help people, after all. Our legal experts and business consultants have been assisting in answering nearly 500,000 questions from small business owners since our founding. With GoSmallBiz Legal, you essentially have an attorney in your back pocket to provide you with the peace of mind that you're acting within your legal rights as an employer. And with your subscription, you'll receive unlimited 30-minute phone calls to discuss legal matters, free document reviews, phone calls and letters sent on behalf of your business, and so much more. Speaking of those legal experts, I am thrilled to introduce one of those incredible in-network attorneys, Mr. Jeremy Schneider of Jackson & Lewis firm.
Thank you very much, Anna. Chris, thank you too. Well, I'm really happy to be here. Thank you everyone for taking the time to learn about some of these important issues. Let me just tell you a little bit about me and about Jackson Lewis. So Jackson Lewis is a full service labor and employment firm. We specialize in really anything having to do with the workplace. That's all we do. If you call me with some random merger question or a business setup question, I'm not going to be able to answer that question for you, but I am going to be able to tell you or point you in the direction of a workplace lawyer who can answer questions about wage and hour issues, about contractors versus employees, which we're going to talk about here, harassment, immigration, all the different things that pose risk to you as employers, especially small employers that are just getting going or trying to grow. These issues come up quite a bit. And so I work in the Washington, D.C. region office of Jackson Lewis, but we have offices in every major metropolitan area in the country. It's about 60 offices all over the country filled with labor and employment lawyers like me. We have a number of practice groups, but really we do advice and counsel is one of our main things. I help clients with everyday employment issues that come up. And then of course, if those issues don't get resolved and they turn into litigation, we will help employers defend themselves in state and federal court and before administrative agencies. This is the brief summary of our practice areas, but I touched on some of these: employee benefits, disability issues, ERISA, financial services, healthcare. Because we're focused on the workplace, we have a really unique vantage point into the human condition. Work is very important. Everybody cares about their job. All small business owners care about their employees, and we're here to help you balance all the competing interests that come along with running a business and managing your employees in the right way. So we're going to talk about a number of topics here that Anna previewed for you, but I like to start off these webinars by saying something that maybe is very obvious, but a business needs workers to grow, right? You are only one person. And if you're a small business owner, of course, you're working hundreds of hours a week. You're billing, you're trying to do as much as you possibly can to scale and grow the business. But there does come a time when you cannot do any more work. And so because you're only one person who can only work so many hours in a week or a month or a year, you have to expand. And so again, part of expansion is a necessary good. Of course, you're going to hopefully grow your revenue. You're going to hopefully be able to do the things that the business needs you to do. But at the same time, there's risk that comes along with it. You really can't do everything as well as a specialist. Lots of employers hire contractors to handle their administrative functions, their bookkeeping, et cetera. What you do best. You may not be an accountant, or you may not be an HR director, right? But you may be really good at selling the work, right? Or going out and getting business for the company. And so when you're scaling, it's better to scale outward than to scale inward. So one of the issues, and I speak with hundreds of employers every month, and one of the main topics that comes up in those discussions are independent contractors versus employees. So the typical question that I'll get is, well, we want to fire an independent contractor employee, or we want to hire a contract employee. And the world of independent contractor versus employee classification is a growing and evolving one in the world of employment law. All of the different employment laws in your state touch on this particular issue. Is your employee truly an employee, or is your independent contractor a misclassified employee? So what does it mean when you misclassify someone, or what are the laws and benefits that apply only to employees, right? So that means independent contractors are not eligible for overtime. Are not eligible for minimum wage. They have protections under the anti-discrimination and anti-retaliation laws across the country. They're also eligible for workers' compensation benefits. They're eligible for unemployment. They're also eligible, depending on whether you offer it, long-term and short-term disability. And they're eligible for leave and other things that employees have access to under state and federal law. Why do we care about this? Most employers, especially small ones, call me and they say, well, we've got this independent contractor employee. And my very first reaction to that is, oh no, because most employers misclassify people who are independent contractors. And there are laws in many of the states across the country that prohibit misclassification. And some of them have significant liability risks to them. So if you misclassify someone as an independent contractor when they should be your employee, you could be liable to the government or to that employee for income taxes that were never withheld, or for FICA, and for overtime and minimum wage compensation, which is usually the largest risk area for misclassification. You could owe for unemployment tax. You could retroactively owe for workers' comp, and other benefits. And so this is a real problem. The Department of Labor the Federal Department of Labor investigates misclassification issues, and each of the Department of Labors all across the country investigate the same things. And this is what they come to collect if you've misclassified someone. So how do we tell whether or not someone's an independent contractor or an employee? There are these bullets here, and we're going to go through some of the tests, but let me just tell you generally how I view it and how I frame it for clients when they call me. Think of an independent contractor, a pure independent contractor relationship, as an arm's length business transaction. Your business sells widgets. And so you want to concentrate on the selling and the manufacturing of widgets. And you want to specialize in that, but you don't have the specialty for bookkeeping or for marketing or for social media. And so rather than hire an employee who is dedicated to that, you go out and you find a business who's a marketing consultant. And that marketing consultant, you engage with them to basically outsource your marketing function. And that person has their own business. That person does this same service for other employers all over wherever they decide to offer those services. And you contract with them in that way. That is like I said, an arm's length business transaction. A lot of small employers especially have this, misconception that they can just designate someone as a 1099, and that means that they're an independent contractor. That's not the case. So here are some of the bullets that sort of identify whether a person is an independent contractor. They're typically a highly skilled professional. They approach you. So, they've sort of advertised their services in a certain area, and you're engaging with them for contract work. You negotiate and sign an independent contractor agreement. You both always intended it to be a contract relationship, not an employment relationship. It's common in your industry. Hiring independent contractors is much more common in certain industries than it is in others. People are paid on a 1099, although that isn't, and no one of these factors is determinative. It's just really a whole picture is what the Department of Labor will look for when they come in to evaluate. And so who knows, right? The answer to whether a person is an independent contractor is a difficult one. Sometimes you just don't have enough information in order to make the determination. And an agreement, whether you've agreed with this person that they're going to be 1099, that's just one of a handful of factors that the law would look at. And no one of those factors is by itself determines whether someone is an independent contractor. And what really matters is whether an employee meets the statutory definition of employee. So again, when you think of independent contractor, think of a plumber, right? Someone who you're hiring for a particular job. They come and they do the work and they leave and they go about their business, and they do their own thing. Control is really what the watchword is here. If this person who you are bringing in as an independent contractor controls the way that they do their work, and they control the manner in which it's accomplished, or you hire them to perform a discrete task, they have their own tools or equipment, and they can go and do the same work for other people, that's much more akin to an independent contractor relationship. There's all these different tests. It seems like every government agency has a different test: IRS, DOL, EEOC. Most tests really come down to what's called the economic realities. And it's really, another way of putting it is the ABC test, which also applies under California law. It also applies in Illinois when you're looking at these issues. So here are some of the questions you're going to ask yourself about whether or not somebody is truly an independent contractor or an employee. Does this person have an opportunity for profit or loss? Meaning, are you paying them an hourly wage and it doesn't really matter how well they do or whether or not they're doing this for other people? But again, think of the arm's length business transaction. You hire a plumber, they're profiting off of their labor. Does this person have a legitimate business? Are they doing this for other people? Do they have an actual LLC or a C Corp or any of these other entities that they actually run their function out of? Is their function ancillary to your business, or is it primary? If you hire someone as an independent contractor and they're doing precisely what it is that your other employees are doing, and that task is the main purpose of the job, they're probably not truly an independent contractor. They're most likely an employee. Here are some of the things that would be red flags if I were asking questions to a client about whether or not somebody's an independent contractor. Are you their only customer? Is your contract with an individual as opposed to a business? Do you provide training for them? Do you provide tools or equipment, or do they work in your office? What would an outside observer who knows nothing about your job assume? Would an outside observer assume that they are your employee if they were just at the work site and watching them interact with everyone? Do they do the same work as one of your, at least one of your existing employees? Are they expected to attend trainings or meetings alongside of your employees? Are they subject to your work rules, like your employee handbook? Did they used to be your employee before you quote unquote outsourced them? And then, of course, if the contract doesn't have a distinct term, you don't really know, it's open-ended. So that's really a crucial issue for employers. You, especially small and growing employers, that you need to make sure that you're treating the people who are working for you accurately as either independent contractors or employees. And some states, including Virginia, where I happen to be sitting right now, the penalties for misclassification include criminal penalties for individuals who misclassify people. So you've got to really, nobody wants criminal penalties or criminal record, criminal record to come about from something that's a relatively straightforward issue. And so, of course, this is really serious, and the Department of Labor's and the different states and the federal government look at this very closely. And they've done so more in the last 10 years than they ever had before. So you're growing, you are looking to bring on more people. Another significant area of risk is interviews and sort of more generally, the hiring process. So what do you do and what don't you do in an interview? One of the things that employers call me very often about are questions that have to do with the type of candidate that they're looking for a position, and whether or not or how in an interview they'll be able to figure out if this person is the right fit, right? Small businesses care about fit more than sometimes large businesses do, because 4 or 5 people all working together, you all need to get along, you all need to have the same goals in mind, you all need to be of the same sort of mentality about our work. And so fit is much more important. And so a lot of times what employers will do is that they either ask the wrong type of questions during the interviews to get at those things, or they don't prepare really for the interview at all. And so some of the things that we recommend to employers to avoid some of this risk is to avoid certain topics, like topics which would have something to do with an employee's protected classification. So, and we'll talk about protected classifications in a little bit, but here are some of the tips. You want to prepare for the interview. Sit down, review the functions of the position, really know what it is the person is going to need to do in order to be successful. Review their resume. I interviewed someone a couple of days ago for a job in our office, and I only spent 5 minutes looking at the resume before they walked into my office. And so it's embarrassing, but I'm telling you this out of one side of my mouth, and out of the other side of my mouth, I'm not doing it myself. But we often don't have a lot of time to really get into the weeds on each individual applicant. But I would encourage you to understand the qualifications and the experience of the people who you decide to interview before they come in. Remember, you're selling this job to the candidate, and as part of that, they're looking for a fit just as much as you're looking for a fit, and they're looking for something that's satisfying, that pays the bills, that has some opportunity for development, and you're looking for someone who's going to be dedicated to your business and who is going to follow your rules. And so it's good when both sides come to the table prepared and ready to have a real discussion about what's going on. You don't want to ask questions that will allow, you do want to ask questions to allow the candidate to do most of the talking, right? The less you talk, the less risk there is. Also, the more the candidate talks, the more you will get a sense for who they are and what they're about. And so I typically recommend you start with easy questions first. Tell me a little bit about yourself. What first attracted you to this position? Those types of things before you then really get into the meat of the interview, which is where you've got prepared questions like, tell us about an experience at your last job where you conflicted with other people or where you had to solve a really complex problem. You want to ask behavioral questions, right? You want someone to describe past experiences. You don't want to ask you do want to ask open-ended questions. Again, if the idea is to figure out if there's a fit and to really get to know someone as much as you can in 30 minutes, You should ask open-ended questions, allow them to talk about themselves. You want to take notes because later, if you make a decision that's adverse to one person, or you bring on one person versus another person, you want to, and there could be some allegation that comes out of that, you're going to want to have notes to justify why you made the decision. One thing that I do, I'm a litigator, and so I take people's depositions, and obviously a job interview isn't as serious as a sworn deposition, right? But one thing that I like to do both in interviews and in more formal proceedings is really rely on silence. People are very uncomfortable when it's silent. And oftentimes you get more and better information from someone when you kind of let silence sit there in the room for a couple seconds. People feel a little uncomfortable. They feel like they need to fill the dead air, and they just keep talking. And so, you can learn a lot from someone about how they react to a moment of silence. You want to ask follow-up questions. Follow-up questions shows that you're paying attention to what someone is telling you, right? This is the difference between sort of active and passive conversations. You want to be someone who takes a snippet of what they just told you and then uses that to continue on with the discussion. You want to ask the candidate you want to allow the candidate to ask questions about the company and who they're going to be working with, et cetera. Because again, not only does that give you good information, but it also gets them a sense of comfort over where they're headed. So here are some example interview questions that we recommend employers use. Obviously, tell me about yourself. What do you do in a typical day? The person we hire is going to be expected to do X, Y, and Z. So why don't you tell me a little bit about your experience with that? Tell me about a time that you had to manage deadlines. I'm a lawyer. Deadlines are my life. It's keeps you up at night, and I'm sure a lot of your businesses are deadline oriented, and you've got to deliver goods and services to a client on a tight deadline. And so asking about experiences with deadlines is a really good way to get at someone's ability to manage their time, someone's ability to triage if necessary, and someone's ability to sort of identify the priorities. How do you get along with your colleagues, right? I mean, again, if it's about fit, and it is for most small businesses, how they get along with other people is going to be very important. What are you good at, or what are you not good at? You're going to get the I work too hard, I care too much, and I am too much of a perfectionist, right? You'll get those sort of canned, silly answers, right? But I remember when I was interviewing for law firm jobs, even though I'm an employment lawyer and have been an employment lawyer my entire career, when they would ask me, what's a weakness, I would say, my answer was always something like, I wish I knew a little bit more about tax law. It comes up in the context of my practice relatively often. And a lot of times I feel like I've got to go to a colleague, or I've got to go outside. I've got to point a client to an outside resource. And so if I could give a little bit better advice myself, we could bill for that time, or the client would have even more comfort over the situation than they do. And that's like a really good answer to a question that asks someone to tell them about their weakness, right? It's a little bit creative. It doesn't mean that they can't do the job, but it does mean that they're thinking critically about, kind of what it is that they're doing and what it is that they want to deliver to your customers. What do you think might be difficult about this job, or what else can I tell you about the company? Again, with the open-ended questions, these are good. If what else do you need to know, or what questions do you have for me? Of course, I have a partner who, when he interviews young lawyers, he always says, what questions do you have for me? And he is very critical about what the answer is that he gets back from that. If it's some sort of stock question that isn't really relevant, he views that as a negative. And I think it's a good question, especially one to kind of end an interview on. People should be prepared enough to give you at least one question. So here are some of the don'ts for interviews. Now, when we talk about anti-discrimination laws, the general idea of anti-discrimination laws is that an employer can't make some kind of decision some kind of employment decision, whether to hire someone or to fire someone or to demote someone based on their membership in a protected category. There are lots of different protected categories. We know the big ones, right? Age, race, gender, political affiliation is one that's popping up a lot now. Disability is another one. We know all of these protected categories. We can't, even in a state that's at will, you can't make an employment decision based on an employee's or prospective employees. This applies to applicants as well, these laws, their membership in a protected activity or in a protected category. And so what does that mean for interviews? That means that you can't ask questions that get at an employee's protected categories. And if an employee is later able to show that you were motivated in some way by either their answer to one of those questions or the fact that they are an older worker or a pregnant woman, right? This comes up a lot. I answer a lot of questions for small businesses when they hire someone who very soon after they start their employment, they disclose that they're pregnant and that they will need some amount of leave in the coming months. And so there are a lot of employers who feel like an employee should disclose that. Unfortunately, the anti-discrimination laws preclude asking questions about an employee's pregnancy or disability, et cetera, any of these protected categories. And then you can't later, and an employee isn't required to disclose these things, and you're not later able to make a decision based on these things. And so one of the don'ts, it comes up quite a bit, is age-related questions. So you're going to want to focus on the substance of the care of the employee's experience as opposed to their actual age, right? So don't state things like your company is a young company or you're looking for fresh and energetic people, right? The EEOC, which is the administrative body that administers a lot of the anti-discrimination laws, they've said that that type of language could be considered ageist. Don't make age-related jokes. I mean, it seems silly to tell people not to make these types of jokes, but you'd be surprised, even if it's self-deprecating, even if it's a joke that's about yourself, that can make a person feel uncomfortable and then could also lead to a suggestion that their some decision you made was based on age or any other protected category. You just want to avoid the topic entirely. Don't talk about their birthday or their graduation day, etc. Race and gender is another area where interview questions sometimes touch. You're obviously, you want to get to know this person. There's again a fit aspect to it. You want to make sure you're going to get along with them. Sometimes when you ask people about their home life or their social interests or their club memberships and things like that, or hobbies, that can become problematic because they touch on assumptions about race or gender, right? So don't, for example, I mean, again, some of these things seem silly to ask, but you'd be surprised when clients call me. Don't initiate a conversation about hip hop music or basketball with an African-American candidate. It's a trope, right? Employers often get themselves into trouble when they're making sort of assumptions based on, stereotypes. Don't, for example, another thing, don't ask about whether a female candidate likes to cook, right? I mean, these are, again, it seems silly to say, but these are racial and gender-based stereotypes that people are sensitive to. And as I'm sure many of you have learned as being employers up until this point, never before in recent history have people been more sensitive and aware of these issues and more willing to bring claims. Again, asking a female candidate about home responsibilities is another one that employers have gotten themselves tripped up on. Don't ask questions about marriage or family status. Again, if it comes up, a person talks about their kids or they talk about their spouse, there's nothing wrong with that, of course. We're people, right? What do we talk about? I talk about my kids constantly. I talk about my wife with my colleagues all the time. But, don't presume things in your questions. Don't ask questions that presume married women or people with children will be less able to work long hours, right? Again, these are touching on these stereotypes. Don't ask questions about childcare arrangements. Again, that's another one that comes up much more often now. If you have remote employees, one of the good things I think about COVID out of the pandemic was that employers now are much more willing to hire people remotely. And so you may be a small business with 3, 4, 5 employees, but you've got 2 or 3 people who work remotely from their home outside of your state. And so that one of the main concerns that employers bring up now is we don't know whether this person, has their child at home or their children at home while they're working. And there's obviously a productivity issue with that. But I would avoid questions about it in an interview. If you later discover that an employee doesn't have childcare and that they are, homeschooling their kids or teaching, or going in and out because of daycare or school responsibilities, that's a productivity issue for an employee who's already working as opposed to a family responsibilities issue for an applicant. It's better to avoid these topics altogether. Of course, pregnancy and childbearing plans, you'd be surprised how many times an employer will ask an employee, well, do you see yourself having children in the near future? And of course, people react negatively to that. It can be something that leads to discrimination allegations. Don't comment on whether or not a person is pregnant. It seems like a joke in a sitcom or something like that, but it happens.
Jeremy,
So,
I'm going to throw a wrench in this. Do you mind,
sure.
before we move on to our next section, we've had a number of questions come in on this topic. So do you mind if we ask you a few questions before we move in?
I don't.
Okay.
Go right ahead.
Wonderful. And I'm going to have you come in here too, but I'm going to kick this off with the first. So one of the first questions we got was, what if we have a current employee? I'm going to go to the independent contractor section.
Okay.
But what if we have a current employee who has approached us about becoming an independent contractor? Is that something that they can do to decrease their hours and only do project work? So essentially, can you convert an employee into an independent contractor?
You can convert them. There's nothing wrong with the act itself of converting an employee to an independent contractor. The issue comes up when the person isn't truly classified correctly as an independent contractor. So you said, can they do project work or, that's one way that you could convert someone from an employee to an independent contractor by scaling down their responsibilities, right? Focusing in on particular jobs that they can perform on an as needed basis, right? I would couple that with an independent contractor agreement, like a written contract that explains, everybody understands that this is an independent contractor relationship. You also could encourage them to set up their own business. I would recommend that as well. I would also recommend that they buy their own insurance, right? That they buy their own healthcare, they buy their own workers' comp insurance, they buy their own liability insurance if they're going to do this for you and for others. There's a way to kind of pull, there's 10 different levers you can pull to make sure someone is truly an independent contractor or as close as you can get to it. You try to pull as many of those levers as you can to make it look like if the Department of Labor came in and audited it, that you really do have an independent contractor here and not an employee.
I think that's great. Thank you. I think that helps a lot of people. And I know you had some questions come in too. Do you want to ask one of these to Jeremy?
Yeah, absolutely. So we've got another one that came in. How about age related? We need people that are over 21 to be covered by our auto insurance and driver company vehicles. This is from our auto insurance company, and it is a requirement. So how would the law go into effect on those types of requirements?
Sure. So I would not put in an advertisement that you need people who are over the age of 21. So I'm going to give you on the one hand, there's the very pure, strictly legal advice. And then on the other hand, there's your business and you have to operate in a certain way advice. So on the pure legal, state and federal agencies look at job postings. If there's an age-related aspect to the posting, they get flagged and you can get complaints based on something that you explicitly put in writing. I understand the practical reality. You need to have these people be insured. So what I would say in a posting, as opposed to saying that an employee needs to be over the age of 21, also, by the way, most states, although it varies from state to state, only protect, when it's talk about age discrimination, it means older workers, meaning people who are over the age of 40, which makes me feel like ridiculous that I'm an older worker. I don't feel like I'm an older worker, but that's what the law says. So in most jurisdictions, it's 40 or over is what age discrimination means. But in some jurisdictions like California or in the District of Columbia near me, age means any age. So you might want to know what your local law is, and that maybe give you a little bit more comfort. If you're getting back to the posting, I would put in the posting, as opposed to we need someone who's over the age of 21, I would put something like must be able to be insured by companies, like by companies driver, company's car insurance provider. Or I would put qualifications, meaning must be able to drive rental vehicles or must be able to drive company vehicles. And then under that, a qualification that doesn't touch on age explicitly, that says you must be able to be insured by our provider. That would probably get you as close as I could get you. If you had to ding someone explicitly because they were 20 as opposed to 21, I think normally with a client, I would have a lengthy discussion about how you're going to handle that in the best way possible. Again, I wouldn't reference the age as a reason why you're letting someone go or not letting someone go, but I would keep the posting itself neutral on the age and focus it in on what the requirements of the position are, which is you have to be able to be insured.
Excellent. I think that's real world advice, Jeremy. So thank you for that.
Sure.
I'm going to ask one, and then Anna, I'll let you ask one more here. So we had one around the types of questions you can ask, and so somebody in the chat said, "Can we ask if someone has upcoming time off or they have any planned time off? Is there a way to identify that without asking, are you pregnant?"
Sure. So a couple of things I would look at. I would probably ask someone, focus more on your start date. Is there going to be an issue starting in 3 weeks? That gets the conversation going. And then I would also, if the work that you're doing is sort of project-based, or there's a timeline based, or you hiring someone for a very specific need, like they need to be placed on a contract in the next 60 days, or they need to deliver a particular project within a very short period of time, then I would ask questions related to their ability to do that, right? You would say, okay, is there going to be an issue with the start date? No. Okay. For planning for the position, is there going to be an issue with you working, toward a deliverable date of this first project in the next 60 days or in the next 90 days? That focuses it away from a protected category and gets you kind of where you want to be. Now, it's a little uncomfortable if a person is visibly pregnant. I mean, I want to make an assumption about anyone being pregnant, right? Because that would be terribly embarrassing, but those are uncomfortable questions. I would say in most cases, I tell my clients, let's have a 10-minute phone call and let's plan for that conversation. Let's try to map out what that conversation looks like so I can give you some bullet points so you can get at what you are trying to get at without coming right out and saying it. It's a tough situation. I'm with you.
Thank you. Anna, you want to ask one more here?
Yeah, absolutely. We do personality profiles. As we are a home help agency to pair them with the right client. How do we ask these to pair them with the correct client if we technically shouldn't be asking or doing personality testing?
You can do personality testing as part of hiring. In most states, I'm not aware of any particular state that outlaws it, although maybe California, because it's crazy out there. It's a really weird place to be an employer. You can do personality tests. What I would say is, well, I mean, if the question is, I mean, was the question whether you can do it or not, I don't think so. I think it was, what do you do with the information that you have? Is that really what? Okay, I mean, you can, again, the law prohibits decisions based on membership in a protected category. It isn't a protected category whether someone is like top right in like these, I've seen the personality tests, these like scales, these color scales, like if you're a purple or a yellow or a green or a blue or whatever these personality tests spit out, that isn't a protected category. You could make a decision based on that. Now, what I would caution you, and I caution clients who use personality tests a lot, is that you should use some of the more established ones, the ones that are more recognized by the general populace, because there could be an argument that, you know, one study or another, or one test or another is flawed, or it's slanted in some way to be adverse to folks of one protected category or another. I usually caution, there's nothing that actually prohibits using personality tests, but I caution about the use of them.
Got it.
Excellent.
Thank you so much, Jeremy.
Sure.
Jeremy, we're going to let you get back on track here and talk a little bit about post-offer pre-hire considerations. And then we'll continue to collect questions. And if we have more time at the end, we'll ask you some more.
Okay, that sounds good. All right, so post-offer pre-hire considerations. You know, a lot of clients will call about background checks. The growing trend in the country is that you can't perform a criminal background check until after you give what's called a contingent offer of employment. So that may not be the case in each and every state in the country, but that's actually where most states are headed. And so a couple different things I would recommend about background checks, and I see in the Q&A recommendations about drug screening too. I'll toss that in there with it. For background checks, interview the person as if you normally would. When you give them an offer letter and you want to hire them, you explicitly say in your offer letter that this offer is contingent upon successful completion of a background check and a drug test if you want to put that in there. Drug testing laws vary from state to state as well, what you can test for, what you can't test for, at what point in time you can test for it. Most states post offer, but as part of a contingent offer, you can require a background check. Some states are a little bit more complicated. Certain things that you can and can't ding someone for, like arrest records in California and Illinois are not things that just arrests are not things that you can explicitly reject an applicant for. It has to be convictions, and they have to be within a certain period of time, and they have to be for a certain type of offense, right? So you've got to, background checks are not just the background check and it's an up or down on whether the person passes. It's a more complicated analysis when it comes back and there's something that's a little bit more adverse in there. I do recommend background checks for many employers, especially if you have people who are going to be working on government projects. You might even have a contractual obligation to perform a background check. If you know the person is going to be dealing with money, or they're going to come into contact with the personal information of other people, those are the types of folks that you're going to want a background check. You're going to want to make the offer contingent on it. Drug testing is a complicated thing to navigate as well, especially with the sort of quasi-legality of marijuana. Federally, it's still illegal, but in many, many states across the country, it is at the state level legal. And so a lot of employers get themselves tripped up about drug testing. Very easy to justify a drug test in a safety related position, a position where people are driving a vehicle, they're operating machinery, they're interacting with children, right? The same is true for background checks for folks who are interacting with children. A little bit easier to justify a background check in most states, but each state has its own requirements about when and what you can test for. So I would recommend diving in and trying to understand where your specific state allows it. I throw conflicts of interest in here. Non-competes is kind of a hot topic in the world. In many states, they're going the way of the buffalo. In California, you can't have a non-compete agreement or a non-solicitation agreement. But I typically ask employees to, or tell employers that they should ask their employees whether or not they have a non-compete from where they're coming from, because you can get yourself wrapped up in a litigation if that employee doesn't tell you that they are contractually not allowed to work for you. And so I typically ask that up front, or I have a policy in our handbook that says that employees are required to disclose whether or not they're subject to a non-compete or a non-solicitation agreement. You know, whether or not you have them is an individual choice. Many states they're banned, or they're banned for people who don't make a certain amount of money. In Virginia, where I'm sitting, you have to be making about $80,000 a year in order to have a non-compete agreement. Anyone who makes less than that, you can't have them with those people. In the District of Columbia, that number is $125,000 a year. In California, like I said, they're unlawful. You just cannot have them, unfortunately. And in many other states, there's a kind of a weird patchwork. And so sometimes it's hard to understand what law applies to you. That's one thing that we help a lot of clients with. We try to help them understand the multi-state issues at play. It's one of the benefits of working at a large law firm with lawyers who work everywhere, is that we have a pretty good handle on what the laws are in each of the different states. Cannabis considerations for pre-employment drug testing. You know, a lot of people have medical marijuana cards in the states where it's legal. The issue that comes up there is whether or not you're disciplining or not, or terminating someone because they have a disability that requires cannabis as a treatment. In those states where medical marijuana is legal, an employee has to have a medical marijuana card. They have to have an active prescription. There are requirements in order for them to even come to you and say, I'm allowed to use marijuana. And so if you get into the situation where somebody tells you they have a medical marijuana card, you should ask for it, or they disclose that they have a medical marijuana card before they do a drug test. You should ask for the medical marijuana card. And each state has a different set of regulations that apply to what you can and can't ask for. I'll answer one question I see in the chat because it's just jumped right out at me. Can you record interviews if you tell them that they'll be recorded? So this, again, is a state-by-state variation. Some states are what's called a one-party consent state, which means that one party of the conversation has to consent to a recording, which could mean just you. Like if I'm having a conversation with you, and I in the one-party state, I could record the conversation in secret because it's presumed that I consent to myself being recorded. In many states, it's a two-party consent, which means that people have to give both parties to the conversation, or all parties to the conversation have to give their consent. So in those states, you can record interviews if you ask and they give their consent. However, there are certain states like California who would probably require, especially if the person revealed personal information about themselves, and something that would be like personally or confidential information, that you may have an obligation to destroy that recording after the interview. But, you know, you can do it. I normally recommend to most employers that you don't. So that's the answer on that. Customer approval, you know, it depends. Again, a lot of this is depending on where the person is going to be, will control, or where, you know, if you're placing someone at a work site, it's not your work site. You could get customer approval for someone to be there, or what their background check is. A lot of businesses, when they contract with one another, part of the provisions in, like if you're a staffing company and you place people with other businesses, those contracts typically have provisions in it that require that you give your people background checks, or that you drug screen your people. So I would look at your contractual obligations. That's most of it comes from contract. Try to make all of this stuff conditional, meaning you can have the job, but we need you to clear this first. All right. Now, I know there was a bunch more questions, and I know questions are like the most helpful thing. So why don't we do some more questions, and then I'll talk about how we stay connected, and then we'll wrap it all up.
Excellent. So Anna and I are going to pepper you with some and answer them as quickly as you can, if you can.
Rapid fire. All right.
Here we go. So I have a question. What is the law regarding salaried employees? Can an employer deduct sick days or force an employee to take vacation days to cover days off? That might be very specific.
All right, let's talk about salaried employees. So really, when you're talking about salaried employees, you're talking about what's called exempt versus non-exempt. There's a law called the Fair Labor Standards Act. It's the federal law that governs how people are paid their wages. A person who is exempt means that they are exempt from the overtime requirements of the FLSA, meaning a person like me, lawyers, I get a salary and I work many more hours than 40 a week. I don't get paid overtime. There's a test for determining whether or not someone is truly exempt. It's a two-part test. The first part of the test is salary basis, which means that a person has to make a certain minimum salary in order to be exempt. Right now, that minimum salary is around $40,000 a year. It's about to go up to about 50, which means that if somebody makes $30,000 a year, they cannot be exempt, period. You have to pay that person overtime. You can't pay them a $30,000 salary no matter how many hours they work. You have to pay time and a half for every hour worked over 40. The second part of the test is a duties test. A duties test means, do they fit into one of the kind of established exemptions? So there's an administrative exemption, an executive exemption, a professional exemption. They all have their own requirements. Typically, managers fall into one or more of these. So if they supervise people and they have the ability to hire or fire people, or if you have people who have a license, like a lawyer or a doctor or a CPA, they're a profession, so they're exempt. If you don't fit into one of those categories, you are non-exempt, and those folks are eligible for overtime. What was the second part of the question? Now I totally lost it.
No, I think you answered actually the core of that question.
Okay.
And I would say if you have a question about classifying exempt versus non-exempt, that's something you should absolutely, good reason to reach out to you through GoSmallBiz. All right, Anna, I'm going to ask 3 questions. Jeremy, yes or no, real quick. Hopefully these are yes or no. If I have am I allowed, if I'm a business owner, am I allowed to ask a potential employee if they have reliable transportation?
Yes.
Okay, great.
You see, lawyers don't like to give yes or no
I know,
questions.
that's why I'm asking you. That's why
I think for the most part, yes. People need to be able to show up for work. I understand where I think yes.
Okay, great. And then again, I'm having fun with you here. Yes or no on this one. If my employees need to be 18, I think this is similar to the question you answered about being 21, but if my employees need to be 18, can I ask that, or can I write it in a job description?
I would ask whether or why they would have to be 18. For most jobs, like if you need to interact with children or you need to interact, there's a patchwork all over the country where there's a legitimate reason why an employee would need to be over a certain age. That, like, for example, if you sell alcohol as part of your job, you cannot be someone who serves alcohol if you are not 18 in most states or 21 in most states. So if age is what's called a bona fide job qualification, meaning there's some law that requires it or some government regulation that requires it, then you can use age as a determinant.
Excellent. I think that's a good answer there. All right, Anna, do you have 1 or 2 that we can pepper Jeremy with before we run out of time?
Yes, absolutely. Can a signed non-compete agreement be a condition of employment pending state rules?
It can, in many states, it can be. You can, as a condition of offering someone a job, you can require that they enter into a non-compete, putting aside whether any individual state would allow it. There's some states that would or would not, but yes, you can.
Excellent. One more question. How best can I find out which states allow background checks prior to providing an offer?
Sure. You probably could Google around. The term that is used is ban the box. Okay. That's like the legal term that these laws fall under. So if you Google ban the box, United States, you might find something out there that puts like a survey together of what the ban the box laws are in each individual state. If you really wanted to know and you wanted to know with absolute certainty, you could connect with me, and we have a survey on that issue and I could help you. But I would talk to a lawyer about that if you really wanted to know for sure.
Excellent.
Awesome. Thank you so much. And folks, I know we've got a couple of you guys still pending answers here, but we are going to have to move forward, I believe, just to make sure that we are being respectful of time. But if you have any remaining questions, please reach out. We're happy to get you answers from Jeremy or get you set up with a subscription. So we'll keep
Great.
going.
Well, thank you all for your time. I'll just point you to our firm. We put out a lot of content at jacksonlewis.com. Right now, with the new administration, there's a lot of changes. We've got a banner up on the front of our website, Trump 2.0. It says it right there on the top of jacksonlewis.com. Connect with me on LinkedIn. I love hearing from people. I love being connected with people. I share a lot of the firm's content on LinkedIn. And so if you want to get some of that, and it's all free, when you ever get anything from a lawyer for free, you could connect with me and you'll get, through me, access to some of our resources. And I think this is you, right?
Yes, it absolutely is. So thank you guys so much. If you've stuck around to this point, we are so thankful that you joined us today for this webinar. So I do want to make sure that you are aware that not only do we offer these amazing legal services as a curated package that is exclusive to our partnership with CareerPlug and for CareerPlug subscribers, but we also offer on-demand tax consultation and a 24/7 IT support assistance feature for the incredibly affordable rate of just $39 per month or $468 annually. However, for our CareerPlug subscribers, we actually offer an even better deal for annual subscriptions by going to GoSmallBiz.com/CareerPlug. You'll receive our services all year long for just $3.99. But the deal gets even better for those of you that stuck around to this point in our webinar today. If you choose to subscribe within the next 30 days, you're also eligible for another $50 off of that annual subscription to receive our on-demand legal, tax, and IT services on top of what CareerPlug already offers you. To receive our on-demand tax, legal, and IT services in addition to CareerPlug's amazing recruiting services. So, from that, I will kick it back to you guys. Thank you so much.
Thanks, Anna. Really appreciate it. So thank you, everybody. Our focus and our goal here today at CareerPlug was to bring in partners that can really help educate our client base. And so hopefully you found this valuable. We are going to be posting this recorded webinar as well as the information in here inside of our resources center at careerplug.com. So give us a few days to get that posted up there, but you'll be able to review this. You'll be able to share it with your team or your colleagues as well. If you want more information about GoSmallBiz, that's actually located inside of CareerPlug's Help Center. So just go into the Help Center and type in GoSmallBiz, and you can get all the information that Anna just shared, and you'll be able to connect with Jeremy there as well. Jeremy, with that being said, I want to thank you for your time today. You answered a bunch of questions. We really appreciate it. And I hope you actually kept several of our clients out of legal trouble. So we really appreciate it, Jeremy. Thank you. And I have a feeling we're going to ask you to come back and do this again.
Be happy to do it. Great to be here.
Thank you, everybody. Appreciate your time and have a great day.